I would like to thank you first for your report, which takes on board many of ECRE's recommendations. So that's good to hear. My name is Bathily. I work in Brussels at the European Council on Refugees and Exiles, which is an umbrella organization with members in all over Europe, but also Ukraine, Turkey. I was invited to actually comment this study and the topic of this conference, and to bring EU perspective from an NGO, of course, of how the EU level is defining or clarifying the rights to integration, if I would say it like that, at the moment. And I think it's also quite important to get this study right now, because the common European asylum system, which is the package of directives, legislation for asylum, is coming to the end, I think, this year. I say I think because some of the directives were reformulated and not formally adopted by the Council, but that, 2013 should be the last year, and which means that in the next years, the European Commission will have to monitor what's going on in member states. If member states do apply and have correctly implemented the directives. So all information, evidence on how is the situation at the local or national level is, of course, evidence organization, but also the European Commission is willing to take on board. Monitoring, as this study shows, is not only to check if member states do comply with their international European obligations, but it's also a way to show how things can be improved, and with some what kind of partnerships or programs needs to be in place to improve the situation. I will begin first with, I don't have any, that will be the only page you will see. I don't have any PowerPoint, but it's going to be brief. I will update what's going on, what kind of legislative change is happening now at the EU level, and not only actually regarding the reception condition directive, but as you know, integration is a multi-dimensional phenomenon. So I would like also to say a few words about the asylum procedure directive, and I will explain why, but also the qualification directive, which is very important for the integration of refugees and beneficiaries of subsidiary protection. And also something more uncovered, but which will be very important in the future, and that is the new fund at the European level called Asylum and Migration Fund. So first of all, the new reception condition directive is almost at the end, which means that the European Parliament and the Council have completed the negotiations in December 2012. But the European Council has not adopted formally the new directive. And one of the reasons is that the European Council would like to put pressure on the European Parliament for other proposals on the table, and specifically Eurodac. Eurodac is the European database of asylum seekers' fingerprints. And the reason why I'm saying that is that it actually gives you an insight of what are the priorities at the EU level. And for sure, the priorities are not reception, the quality or the standards of reception conditions, but more Eurodac, Eurosur, Frontex, and the budget for external dimension. Secondly, the Asylum Procedure Directive There has been some amendments, and these amendments are still under negotiation, but like for reception condition directive, these directives should be formally adopted this year. The qualification directive was adopted in 2011, which means that member states have until the end of this year to transpose this directive in their national legislation. And at least but not last, the regulation for asylum and migration fund. And negotiations for this fund have started between the European Parliament and the Council. Normally, again, an adoption should happen in 2013. But of course, if an overall agreement on the EU budget is reached. The question I'll take for this comment is, from an EU perspective, are refugees and asylum seekers entitled or subjects for integration? If we take the case for people who were granted a status, then we have to look at the qualification directive. And already, if you read the qualification directive in the preamble, it's very clear that this directive acknowledges not only the importance of integration, but also the fact that that member states have to comply with international obligations. And the qualification directive defines the rights refugees and beneficiaries of subsidiary protection have with regards to access to employment, social welfare, health care, and access to so-called integration facilities. So it recognizes the importance and the legal basis of these rights, but also the specificity of these groups. And the specificity of refugee groups is anchored in different directives, of course, following international, and it says clearly that member states have to take into account specific needs. So, for instance, member states should address problems which prevent beneficiaries of international protection from having effective access to employment-related educational opportunities and vocational training. Another example is that member states should address the problem of recognition of qualifications. I would like to nuance this clarification anchored in the qualification directive, because the qualification directive, even though it aligns the rights of refugees and beneficiaries of protection, subsidiary protection, it still includes a difference between these two groups. So, for instance, beneficiaries of subsidiary protection would have different rights regarding the residence permit, the duration of the residence permit, but also the access to the labor market. And this distinction between these two groups is also clear in the Family Reunification Directive, which excludes from its scope the beneficiaries of subsidiary protection. And the reason why I'm mentioning that is that the report of Professor Sudqua, was very interesting in really repeating or insisting on the multidimensional aspect of integration, and the fact that if people are separated, do not have access to family reunification or access to housing, then of course the integration path becomes very difficult. So then, for asylum seekers, that's of course totally a different story. Then we have to look at the recast, which is the new reception condition directive. There are mainly two articles. One that has not changed, actually, Article 14, about schooling and education of minors, and which states that minors should have access to education under the similar condition as nationals. So no change. But then we go to Article 15, and there's a new thing, subparagraph 1 and 2. The first paragraph says that member states shall ensure that applicants have access to the labor market no later than 9 months following the date of application. We advocated for 6 months delay, and it was also in the proposal of the Commission, but the Council extended this delay. And then this article adds that so they should have access no later than 9 months, and if the delay in the procedure cannot be attributed to the applicant. And that's an important element because it leads us to the asylum procedure directive, which is also under negotiation. And this provision reintroduces the possibility to extend the period during which an asylum seeker can be denied access to the labor market to 1 year in two situations referred to the asylum procedure directive. So in other words, this article actually makes the link between the extension of time limit for the asylum procedure and the access to the labor market, and without clearly defining actually what will be the failure, what will be considered as the failure of the applicant to comply with his or her obligation. And that's, of course, a very important element because that means that in practice, not only there can be an extension of this denial to the labor market, but also more conditions for people to have access to the labor market. So that's it for the bad news. There's a slight improvement in the reception condition directive, which is the second paragraph of this article. And there's a new wording which was included in this article. And it says that member states shall decide the conditions for granting access to the labor market for the applicants in accordance with their national law while, and it's important, while ensuring asylum seekers have effective access to the labor market. And this new wording actually implies a positive obligation for member states to ensure effective access to the labor market. So that's for us. For you it might be the minimal improvement, but for us it's still an improvement because it means that if a member state applies or introduces many obstacles for this access, then it doesn't comply with the directive. And then the last thing is the new asylum and migration funds. So you had at the European level, you had different funds. The integration fund, which was targeting only migrants or economical migrants. And then you had the European Refugee Fund, the Return Fund. And now the Commission's proposal merged the Return Fund, the Integration Fund, and the Refugee Fund into one fund called the Asylum and Migration Fund. And the NGOs actually welcomed this merging because one of the reasons the European Commission said is that that would address actually the differentiation between groups. If I'm talking about integration, like more concretely, an NGO or a local authority is implementing an integration programs, previously could not accept asylum seekers or refugees if it was funded by the integration fund. So this new fund would have been the possibility to actually offer services regarding people's needs and not people's legal status. Well, it seems that it will be a dream because the European Parliament followed this proposal, but the European Council steps back from the Commission's proposal and introduced a may clause, which actually say that member state can, of course, do differently, but tends to exclude asylum seekers from integration policies programs funded by this new fund. And I think it reflects what was said today, but at the European level, for sure, and it's not new, asylum seekers are not entitled to integration. I mean, are not spoken into integration terms, because this is supposed to be temporary, and they can integrate only when their status is granted. And I think that there's two things. I mean, a final thing I'd like to add is that integration was never really defined at EU level only for refugees, or, I mean, in their specificity of these groups. And so I think it's very important to see the general discourse on integration. And there has been a shift between what was supposed to be integration measures, supposed to support and facilitate integration and social inclusion, to what is now more and more used, the term is more and more used as integration requirements. So people are required to integrate, and in order to integrate, they have to fulfill certain requirements. We have that in the family reunification policies, but also access, I mean, other areas linked to integration. And for sure, until now, refugees and beneficiaries of international protection, to some extent, are protected from these integration requirements, but that's the discourse. And for sure, asylum seekers are excluded from this protection. So as usual, I finish with a very depressing note when I talk about the EU level. But maybe, and that's why for me this conference and this report is quite interesting, is that in this field the EU level will not be an actor of change for change, but when we look at the practices at local level from municipalities, local authorities, it might actually, these actors might actually push for some legislative change. As you finished the report on about Hamburg, the situation in Hamburg, and that the municipality could push for changes at the federal level, and maybe the change will come from this level, but do not expect anything from this from the EU level. Thank you very much.